Right, good morning, everybody. Welcome to our Mills and Reeves Spring Employment Law Update. By way of a quick introduction, I'm William Downing. I'm a partner in our Employment, Pensions and Immigration National Service line.
And good morning, everyone. I'm Rebecca Cockrell. I'm a Principal Associate in the Employment team.
What are we going to cover today? We've got three areas to look at. The first is a case law update, where Rebecca's going to be looking at some of the recent cases around settlement agreements and settlement agreement discussions. I'm going to look at an instructive case in relation to dismissal for ill health. We're secondly going to look at some proposed changes to UK legislation around flexible working and what the government are pushing through the statute books at the moment. And then finally, we'll just do a little bit of horizon gazing at some of the proposed changes to put on your radar for the future. Rebecca's going to discuss the first topic and has got a poll for you, I think, to start off with.
Yep. So just to get everyone engaged, we've just got a quick poll for you, if you don't mind completing that. So have a look, and when preparing a settlement agreement, when it comes to the list of claims being settled, do you include a long list of every possible claim, tailor the list to the individual claiming circumstances, include only specific claims, or leave it to the lawyers? So if you don't mind just filling that in. And then when we've got enough, we will close it down. Okay, there we go. So not unsurprisingly, the most of you leave it to the lawyers, which isn't that, but you have got some brave ones amongst you who do it themselves. So why are we asking this? Well, we've had a few cases recently that looked at how you might approach settlement agreements, and they might actually cause you to change your mind a bit. So taking a look at the first case, we've got that of Bathgate versus Technic. So this looks at and clarified and confirmed what probably, when you think about it, is probably a fair and reasonable point, but namely that a settlement agreement can only settle complaints which the parties know about at the point the agreement is signed, so not future claims that haven't arisen yet. So just as a reminder, to be a valid settlement agreement, it must meet various conditions, and one of those is that the agreement must relate to a particular complaint. And we see from this case that when we're talking about a particular complaint, simply referring to its legal character, so just saying age discrimination or its section number, is not going to be enough to essentially identify the particular complaint that you're trying to settle. So if we have a look at that in a kind of factual context, in this case, Mr. Bathgate signed a settlement agreement in January 2017. He received an initial payment under that, but under the terms of the settlement agreement, there was an additional sum due under a collective agreement in June 2017. But in between him signing the settlement agreement and the June period, the employer decided to change the collective agreement for everyone and make it so that additional sums would not be paid to those over the age of 61. So he was no longer entitled to the payment, and he brought a claim of age discrimination, saying that that was inherently discriminatory. So the question for the employment tribunal was, had he waived his right to bring an employment tribunal claim in relation to age discrimination because he'd signed the settlement agreement, which did reference age discrimination. And he got to the EAT, who said no. He'd signed the settlement agreement before he knew that the collective agreement was going to change, so before he knew the existence of the claim. So the settlement agreement, even though it referenced age discrimination, wasn't enough to prevent him from bringing that kind of claim. So what are the practical implications of that? Well, as I say, when you look at it on the facts, it probably seems fairly fair and reasonable, but it is a departure from existing case law where we've had some legal uncertainty about how you settle statutory claims looking forward. And I think what it reinforces that when you're entering into a settlement agreement, you need to be aware of the potential litigation risk that you're trying to settle and what realistically may arise. and seek to tailor the settlement agreement to individual claims and circumstances. You also need to be aware of the risks of using precedent agreements. And I'm sure none of you do this, but where you save as over an existing settlement agreement that you've used before, that can create problems because you'll have tailored it to the individual in question, and actually that can create problems and not settle all the claims you need. But also it's worth including an employee warranty that they aren't aware of any claims. Just nothing more really than deterrent to try and, you know, flush out if there are any other claims that they're anticipating. And you might also consider going the ACAS route and using a COT3 agreement, so the agreement that you use via ACAS, as that has less limitations in terms of potential claims that need to be settled. So that was the first point on settlement agreements. The next one is just looking at the without prejudice rule. So this, just as a reminder, is separate to protected conversations, which we saw introduced a few years ago, which are useful in relation particularly to unfair dismissal type claims. But looking at without prejudice, which has always been around, but has been a very complicated area of law, and the recent case laws just reinforces that. And I would probably say that it's less useful than the protected conversation regime, particularly at the early stages, because one of the key points as to whether without prejudice bites or not is whether there is already an existing dispute when you have the discussions. And even then, if you meet all the requirements around without prejudice, it's not an absolute right of privilege. There are several exemptions to it. And one being the privilege can fall away if you've acted improperly or with unambiguous impropriety. So the rationale and circumstances around why you're having the conversation do matter. So we've seen two recent cases which really do show how nuanced it can be. And if we take a look at the first case, this looks at the question of whether the rule would apply, the right to without prejudice would apply where the employee hasn't already brought a claim. So does it only apply where they've already brought a claim, or can you have it at an earlier stage? And in this instance, it was at the grievance stage. So it looked at what was said in a grievance meeting where a without prejudice discussion had taken place. And it held that actually, yes, at that stage, even though there hadn't been a tribunal claim submitted, there was a dispute, but it was quite fact sensitive because the employee concerned had already made references to going to ACAS, and the language of the grievance was such that it was clear that there was indicative of a dispute existing, there were threats of claims, etc. So in that case, it held, yes, there is an existing dispute. The employee, as a secondary argument, also said, well, okay, if there is without prejudice, it shouldn't apply anyway because the employer had acted with unambiguous impropriety. And the tribunal looked at that, and the allegation, shocking allegation, was that HR had been intimidating and aggressive. And I'm sure you've never had that allegation come across you before, but the tribunal looked at it, and just to reassure you, they said, no, look, there's a very high bar here, and we would expect to see, you know, threats of taking someone to court or something like that to get into unambiguous impropriety. So helpfully it did say that there was a dispute and the without prejudice rule applied. But in contrast to that, we've also seen another recent case that held the opposite, and that without prejudice didn't actually apply. And in this case, the key question was whether the meeting where the offers were made, whether at that meeting the parties contemplated or might reasonably have contemplated litigation. And at the relevant time, the tribunal found that there was no hostility or threat of dismissal, and the parties were amicably moving towards settlement and a straightforward settlement agreement. And both parties believed that they would reach an amicable conclusion. So as a result of that, they found that the proposal for a settlement agreement was because of commercial good sense and caution, not because of a genuine fear of a claim. So in contrast, in that case, it was too early almost for the without prejudice to take effect, and so they held that it wouldn't apply. So again, what are the practical implications? Well, I think it's fair to say it demonstrates that it's really very difficult to be confident that you can rely on without prejudice. It's so fact sensitive that it can go either way. So you do need to be careful about what you're saying, and I'd always script it or plan it in advance before you enter into a without prejudice discussion and consider whether it is appropriate. And again, think about the protected conversation regime and whether actually that would be more appropriate.
I'm going to talk about a case involving dismissal for long-term ill health. And as a quick reminder, most of the situations where you are dismissing someone with a disability for long-term ill health, the claim that will arise, obviously including things like unfair dismissal and what have you, will be under the discrimination laws, a discrimination arising from disability. And the two parts to that type of claim are where the employer is alleged to have treated the person unfavorably because of something arising in consequence of their disability, which in almost all circumstances of dismissal for ill health will be the dismissal for the absence. And then second, and crucially, the point that we'll be looking at in the case is, can that decision be justified as being a proportionate means of achieving a legitimate aim? So as it says in the red type there, essentially what you're looking at is dismissal for the absence, and then looking to see if you can justify that dismissal under the proportionate means of achieving a legitimate aim. In the case of DWP and Boyers, decided recently, the background to this was that Mrs. Boyers was off sick for over a year due to ill health. She had migraines and was affected by stress and also suffered from a depressive disorder. And in essence, this was due to a break, or was caused by a breakdown in working relationships with a colleague. That led to stress and these conditions, the migraines and the depressive disorder. The situation was managed and dealt with over that period, and in the end there was an agreement for Mrs. Boyers to return to a different office on a 6-week trial period. She refused to return to the Middlesbrough office because of this. The colleague was still there, and so DWP was able to organise a trial period in a different office to see if she could settle there, and to test whether that would actually make any difference to her conditions and allow her to return to full-time working. The employer in that situation decided that the 6-week trial had been unsuccessful and dismissed Mrs. Boyers at the end of it, and that led to various claims, including a claim under Section 15, the discrimination arising from her disability. The Employment Tribunal was satisfied that DWP were pursuing legitimate aims. The legitimate aims that were put forward were firstly the protection of scarce public funds. As a publicly funded organisation, they had to be careful how they spent their money, and at some point were no longer able to fund someone who was no longer working, and also to reduce the strain on other employees by having someone who was absent. And I think that's a situation that is commonly looked at by employers, both in the public sector and outside the public sector. And there will be other situations, other legitimate aims involving essential business needs. You know, if you've got service level agreements, you've got customer demands, etc., then those can amount to legitimate aims. However, the Employment Tribunal and the EAT, who looked at it at the end of last year, decided that DWP's dismissal was disproportionate. It wasn't a proportionate means of achieving those legitimate aims. And two points arise, really. First, in the specific circumstances, DWP hadn't properly evaluated the trial period. They didn't have any notes, they didn't have any evidence of what they'd done during that trial period. They couldn't justify what the reasons for deciding it had been unsuccessful with any contemporaneous evidence, and the witnesses were hazy on what had taken place in that period. So they couldn't justify it on that basis. And secondly, the EAT made the point that the analysis of whether it was justified or not has to take place at that point of dismissal. The whole process up to that point needed to be reviewed, but they also needed to review the dismissal at that time. And some of the practical implications, I think, some of the learning points, if you're faced with a similar situation, is to try and avoid acting prematurely. I think from my experience, there's obviously you get to that point where you've had a long period of absences, and there's some pressure to when the decision is finally taken that dismissal is the right approach to do that quickly. But I think the DWP case shows that you do need to spend that final extra time reviewing the process and reviewing whether it is in fact asking that question if it's proportionate to dismiss at that point. And part of that consideration is to genuinely consider alternatives to dismissal and make sure that you have thought about those if there are alternatives, and if there are alternatives, why you are rejecting those as appropriate courses of action, and to carefully and systematically evaluate those, try and avoid a broad brush approach, but to look at each one in turn and decide on those, and then to keep that clear and contemporaneous record of those decisions in the meetings and in the final letter. And I think if you can do that, then you will learn the lesson that DWP learned the hard way, and be able to justify any discrimination arising from disability. That's the end of the case law section. We're going to move on to the second section now, which is other developments that are coming through Parliament.
And just to get you going, we've just got a quick poll again, and this is a quick poll just to reassure you. So would a 4-day working week work in your organisation? Yes, no, it's complicated. So like I say, very short and sweet. So if you fill that in, see, I mean, I think I can probably guess what the outcome. I'm going to say most people say I don't know, it's complicated, but we will see. Okay, so there we go. Oh, it wasn't quite as clear cut as I thought. So 44% I don't know, quite a lot of yeses, and then equally probably not that far off equal amount of no's as well. So it is interesting how there's quite a lot of split across the board. We have just seen in February this year the publishing of the results of the 4-day working week trial. So this was a trial that involved 61 companies from a range of sectors, took place over a 6-month period from June to December last year. And it was definitely not a one-size-fits-all approach. They all tailored their approach slightly differently, all the companies involved, and how they structured the 4-day week. So it wasn't just the classic Friday off. Some did do that, but some also looked at staggering it. So they still had a 5-day business. Also, some people look at annualized hours, but based on a 4-day working week. Now, they claim it's the world's largest coordinated 4-day week trial to date. And the report describes the trial as a resounding success. So why are they saying it was a resounding success? Well, if we look at some of the statistics that have been published, so they've found that 92% of the companies who took part are apparently continuing in some way, shape, or form to a 4-day week. But 30%, and I suppose you could look at this as a positive and a negative. I was about to say only 30% have confirmed it as a permanent change, but that is still a significant amount have committed to that on a permanent basis. Some of the most extensive benefits of the shorter working hours were found in relation to employees' well-being, and the before and after data shows that 39% of employees said they were less stressed. They also found a drop in absenteeism. So they measured sick and personal days per employee per month and found that there was a reduction in 65% of the cases. But they do acknowledge that given the short time frame that was involved, that they're unable to say if that is statistically significant, which I think in simple layman's terms means it's too short a period to know whether that's going to continue in the long term. They also saw resignations dropped by 57%. And in terms of the revenue, so the kind of business case side of it, they saw that basically stay approximately the same, a slight rise by 1.4% over the trial. As part of this trial, at the outset, all the businesses who took part had to consider ways that they could increase their productivity. So they actively looked at that in advance. And some of the most common ways that the businesses identified efficiencies were including shorter meetings with clearer agendas, reforming email etiquette, so making employees think about the purpose of the message and who actually needs to be involved, who needs to be copied in. Also introducing uninterrupted focus periods, so periods of time when employees knew that they wouldn't be disturbed and so could just focus on particular complicated work. They also asked employees to analyse each step of the production process or their processes to see if there were any aspects that could be automated. Some businesses promoted monotasking, which is essentially the opposite of multitasking, so eliminating the time wasted on switching between tasks. They also suggested task lists, which I love. I have to say, I always do a task list. It's both at the end of the day, so you can start the fresh, then following day, you hit the ground running, as it were, and also to hand over to employees if you're on holiday, etc. And finally, reducing staff involved in a process to free them up to do other things rather than just reducing your staff numbers overall. So it's interesting to see that obviously they went about these efficiencies because they were thinking of reducing it to a 4-day week. There is a cynical part of me that you could look at this regardless of whether you drop down to a 4-day week, but it's clearly out there. It's something that is still hotly talked about. So it's probably something that as HR professionals you need to start thinking about and whether and engaging with and thinking, is there any scope for that or not?
I'm going to look at some more flexible working changes that are coming down the tracks. And I've seen a comment and appreciate this isn't going to affect all industries, but certainly the direction of travel for the government is to look at flexibility within the working arena. And the first change I wanted to highlight for you is the proposed private members bill to alter the existing flexible working framework. And it's proposing to do that in those 4 ways set out on the slide. Firstly, it would require you to consult if you're considering rejecting a request. Under the current ACAS statutory code, you would hold a meeting with the person requesting the change, but then would go away, consider it, and only need at that point then to write to them to accept or reject the request. But this proposed change would require you to go back and have further discussions if you were considering rejecting it. The second change is to increase the number of requests that can be made from 1 request to 2 requests in a 12-month period. This third change would be to reduce the decision period from 3 to 2 months, which would keep the pressure on you to consider those requests and make management deal with those much more speedily than they have to currently. And then the final one, which I think is rather a shame personally, but it would be to remove the need for the employee to suggest how you might deal with the implications of the request. Currently, you can ask the employee in their written request to say how it would affect colleagues, how it would affect the service delivery, and suggest ways of dealing with those effects. And you can ask that in the meeting you have with them. The proposal is to remove the need for the employee to turn their mind to that kind of thing. Obviously, you could still discuss it in the meeting, but it does seem something of a shame that particular issue won't now be addressed up front. The other words from government is that they are intending to make the right to request flexible working arrangements a day one right. Currently, you have to have 26 weeks continuous employment to make a flexible working request, but that particular point hasn't come up in the private members bill. But given the government's majority and their wish, that is something that we're keeping a close eye on. The second private members bill is slightly inconsistently, given the push for flexibility we've just been talking about, a right to give people an opportunity to ask for a predictable working pattern. This has really come out of all of the various inquiries and high-profile cases that we've had concerning the gig economy and the media interest in, the accusations of exploiting vulnerable workers. And it's given rise to this private members bill, which again has got government backing, to give a right to workers to ask for more predictable working patterns. The proposed legislation would then allow employers to refuse that request on specific grounds, so very much following the flexible working framework. But crucially, it's going to apply to all workers and employees, and that will include agency staff. It says, without specifying, that there will be a qualifying period before that request can be made. But for agency staff, it's suggested that that would be a 12-week period. So after 12 weeks, when the other agency worker rights kick in, that would also be a right to request a predictable contract. And the other suggestions, it will be a qualifying period of 26 weeks, like it is in the current flexible working request regime. But those weeks wouldn't need to be continuous. If you've got flexible workers work for you on and off over the time, then they can aggregate those weeks that they work for you. And similarly, it would be 2 requests a year, like under the flexible working request currently. This is an early stage bill at the moment. It's still at committee stage, and we haven't got a date on when that will come through. But I think it does have some important practical implications. It's obviously a right to request, not to have, so there will be the similar responses that you can do to flexible working requests currently. But nevertheless, there will be a burden in considering those requests, management time involved, and you will have to give good reasons for not allowing that work pattern. There will be compensation for breach, but that's expected to be limited. Again, the bill currently says that there will be a remedy of a declaration, so a declaration that the employer has got it wrong. And secondly, a number of weeks pay for that breach, which will be specified by Secretary of State. So we're not talking about the kind of unfair dismissal discrimination levels, but nevertheless, there will be some penalty for a failure. There will also be that protection against victimization. So if someone has made a request for a particular work pattern, they can't then be subject to a detriment or to dismissal because they've made that request. But I think there will be some changes to how flexible you can be as an employer. As I mentioned, with agency workers can make a request of the hirer if you're hiring, and obviously against their own employment agency. So that 12-week period would become quite significant, and use of agency workers would become significant. I think the second issue is around fixed-term contracts, because they will be presumed to lack predictability, and so they would fall within the ambit of this right to request. So people on fixed-term contracts could ask for longer-term contracts or even a permanent contract, and I think you'll have to give careful thought to the use of fixed-term contracts and how suitable they are. give more thought to that maybe up front, given that those could be subject to a request for predictable working pattern. And then if you do use casual workers or hour workers, those kind of flexible employees, then again you may want to have a look at how you manage those because of the this right to request. And on that, we've just got a quick poll actually, just to try and take a temperature on how flexible how flexible your workforce is. Do you have a casual worker in your organisation that this new right might apply to? Yes, no, don't know. See how widely this could affect. Let's see what the answers are. Right, so that is a significant number of employers, over half, who have got casual workers where this right to request can impact, with some that don't know. So I think you should keep an eye on this, because I think obviously it is going to be something that you're going to have to start thinking about now, particularly which parts of your business may be affected, and start to think about how much flexibility you really need, and how much of those requests could be accommodated, and if not, why not. So that's the end of the second section that we were going to talk about. We're now going to move on to a final section, which is very much looking at what's on the horizon for longer term changes to UK employment law.
Okay, so we're seeing various pieces of potential new legislation coming through via private members' bills, which is slightly unusual, but the government is backing them, and I think just seeing it as a way of getting them through. But we don't have any clear dates as to when these are likely to come into force. But in terms of the potential new areas of legislation, we're seeing a new legal duty to prevent sexual harassment at work, and there's two key proposed changes here. So to increase the protection, one is a new duty on employers to take all reasonable steps to prevent sexual harassment in the workplace. And we don't know what that will look like yet. But also the second step is to restore the protection that some of you may recall from when the Equality Act first came in, which was against third-party harassment. So where someone outside your organisation harasses someone within it, and an obligation to ensure that you take all reasonable steps to prevent that kind of harassment. So we've already seen some challenges to that in government in terms of narrowing and giving exemptions. So we're not sure what that will look like, and I suspect it won't be quite as straightforward as the currently proposed, but it's a definitely keep it under review and watch this space. The second point you may have heard about before and has been talked about for some time, and that's the extension of the redundancy protection to new parents. So as you'll be aware, currently someone on maternity leave gets additional protection in a redundancy situation, as they have the right to priority in the search for alternative employment. The proposal is to extend that protection to those who are pregnant, and also to those who've recently returned from a period of family leave. So that would be both parents, whether it's maternity or paternity leave. I think that probably will come through, because as I've said, we've heard that talked about for quite some time now. Also carers leave, so a week of unpaid leave per year to care for a dependent with a long-term care need. And also looking at neonatal leave and pay, so a new framework to support parents of premature or sick babies by providing neonatal leave and pay. The full details would be subject to regulation, but the current proposal is that you would get 1 week of leave for each week the baby is in neonatal care, up to a maximum of 12 weeks. That accrued leave, depending how long they are in neonatal care, will then be added to the end of the maternity or paternity leave period. And finally, we've got a proposal for supporting those receiving fertility treatment by introducing a right to paid time off to attend appointments for fertility treatment, and also going a step further, the right to unpaid time off to allow a family member to accompany someone to attend such appointments. So there's a lot going on, and it's just the government is supporting all of these. It's just a question of when they'll actually come through.
Sorry, I forgot to unmute. Another area where the government are looking at is in relation to limiting strike action. They've issued some review of the current situation we've had on striking, and have looked at it in terms of human rights legislation, and particularly the right of assembly, and the right to be a member of a union and take strike action, and also under the economic provisions. And what they've decided is that there is a case for, what the advice is there is a case to impose regulations for minimum service levels in certain areas, including fire, ambulance and rail. Fire and ambulance on the basis of the danger to life from strike action in those sectors, and the railways because of the impact it has on the economic well-being of individuals in the country and getting to and from work, for instance. So the government has said that on the basis of that advice, they will impose legislation which will make minimum service levels a requirement in those areas. There is currently provision for voluntary minimum service levels to be used, although they aren't widely used, and in the analysis are widely thought of as being ineffectual. But they've kind of backed down, I think, really on education and the health services, where they will hope to deal with that by voluntary agreement. Obviously, that's not directly relevant to any organisations which aren't in those particular sectors, but it does have an impact on your staff, as we've all noticed over the last few months, where when the teachers strike and kids are at home, what have you, it does have an impact on your business. So that's something to keep an eye on, and we'll see where that ends up.
Okay, and finally from me, we've had some government consultations that we just wanted to flag to you in two particular areas. So one has now closed. I have to say I'm very pleased about this consultation, and I do hope that it does get somewhere, because this was looking at calculating holiday entitlement for irregular hours workers. So anyone out there who does have casual workers will know the pain of trying to work out the most efficient way of calculating holiday entitlement. And obviously we've had the hiccup that is the case of Harper versus Brazil. So this consultation is specifically looking at addressing that point. Sadly, it doesn't go any wider than that. It is just looking at addressing the anomaly that has been created in respect of part-year workers. And the proposal is to introduce a holiday reference period for part-year irregular hours workers, and proposes a two-step calculation for how you would work out the holiday entitlement. The first step is to calculate total hours worked in the previous 52 weeks, and crucially you would include in that 52 weeks where there was no work undertaken. So it is just 52 weeks. So you calculate the total hours, and then you would multiply it by the old favourite of 12.07% to produce holiday entitlement in hours. So there's no plans to expand it, introduce new legislation beyond the issue of those part-year workers, but it is useful if that does get through. That has now closed, so we just have to wait and see what the outcome of the consultation is, but I'm sure for those of you with the part-year workers will be looking with interest to see if we get some clarification around how we should be calculating that is fair and reasonable. And the second consultation, which is still open, so you can still engage with and contribute if you wanted, is the draft code of practice on dismissal and re-engagement. So this is the fire and rehire, as unions like to label it. And essentially they've published a draft code of practice on how employers should behave if they are going to instigate a dismissal and re-engagement process. And like the ACAS Code of Practice on Disciplinary and Grievances, if you fail to follow it, the proposal is that you would get a 25% uplift on any successful claim. The key message of the code is that this really should be seen as a last resort, which I think probably realistically is the case for most employers, just because it is a significant undertaking in itself to instigate the dismissal and re-engagement process. So I don't think it's groundbreaking in terms of what is included in the code, but it is just something to be aware of. And like I say, if you do have strong views on it, you can still contribute to the consultation, which closes on the 18th of April.
And just finally, we've got the new rates that are in play for 6th of April 2023. We won't go through this in detail because you can get the information from our website. But I think there has, you'll see, been a huge increase in the upper limit for unfair dismissal compensatory awards to 105,000, up from 89,000. So that's a significant jump, and I think we'll certainly put it on the radar of most of the finance directors that I have to deal with from time to time. And then the Vento bans, so those are the bans for injury to feelings awards for discrimination claims. Those two have increased considerably, and you'll see that the upper limit has been extended to 56,200. So as I say, those come into effect for claims in relation to dismissal or discrimination, successful discrimination and unfair dismissal claims for after 6th of April 2023. And then a week's pay is obviously feeds into the calculation for redundancy pay and that kind of thing. So just wanted to highlight that for you. Right, we've got 2 minutes left. We've got some questions. We've had some excellent questions. Thanks very much for posting those. I think some clarifications around the flexible working framework, which I can deal with. One of the questions was whether there are any changes to the reasons for refusing flexible working requests, and that isn't. There are no changes to that proposed. So there will still be those reasons that you can that you're familiar with now. Will follow through. It's more about the process that's changing and the time limits. There's a question about the point that said that that the employee doesn't need to give you information about how it could affect the business. That's right. So currently they are required to give that, but there's nothing to stop you from asking that and for exploring that, because at the heart of it, that is what is the flexible working request and potentially the reasons why you would refuse that. So yes, while they don't have to give that information up front, there's nothing to prevent you from exploring those issues with them. And then the third question on flexible working requests was whether there's any time frame, imposed time frame for that second consultation. The point that we will now need to have that conversation if we're looking to refuse it. That will still be under the one-to-one consultation type process. There's not going to be any statutory consultation period for that. It'll be within what's reasonable as currently under the ACAS code. Those are the flexible. Did you want to deal with the
just a couple on the settlement agreement? So they're interlinked, so they're around the difference between protected conversation and settlement agreements, and also kind of the point that you use them. So the key difference between protected conversations and settlement agreements is when they without prejudice. Protected conversation is a statutory regime. It allows you to have a frank conversation with employees, as long as you abide by the code of how you should approach that. It doesn't protect you in discrimination cases, so there are situations where it's not appropriate, and one of the questions was around maybe using settlement agreements in capability routes, which is always a slightly more risky option, and where you might try and rely on without prejudice more, because obviously disability discrimination is a key issue there, and the protected conversation may not protect you. So unfortunately it's very case specific, and you both could apply. You could have protected conversation and without prejudice applying at the same time, or one or the other may apply, and it does just depend on the circumstances. And why I kind of stress that you do need to kind of think about it in